Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this live legal educational content, and today may be the day I earn your subscription. We have a panoply of stories, a set of stories, a quadrilateral of stories, a quartet of stories. That was better. Yeah, we have four stories. Four stories we're going to be covering for you today. These stories are the state of Pennsylvania is attempting to appeal the Bill Cosby issue to the U.S. Supreme Court. Why? New information on the Alex Baldwin shooting at Rust. We have some things dealing with Joshua Duggar, the guy accused of, possession of prurient child material, and we'll discuss that a little bit. And we're also going to discuss, what else did I have on the list? Oh, yes, Potter. Kim Potter, the taser cop, who is currently on trial. So we'll be discussing some of those things tonight, so that will be exciting. So let's go ahead and pick up right away. Let's go ahead. Yeah, Kobe, I caught it this time. Anyways, let's pick up right away with the state of Pennsylvania appealing the issue to the U.S. Supreme Court. So those of you, my friends, will want to remember some of the background on this. So for those of you who remember, Bill Cosby was tried and convicted of various misdeeds involving Quaaludes, and he was sentenced to prison for, the stuff with the women, which was, not great. And the Pennsylvania Supreme Court, the highest court in Pennsylvania, upon review of this case, decided to throw out the case. They concluded that the prosecutor in the case had made multiple public statements regarding Cosby's participation and that it wouldn't be used against him. Now, this wasn't done as part of a formal plea or formal agreement. So it wasn't done as a formal plea agreement, or it wasn't done as part of a formal non-prosecution agreement, or it wasn't done in any formal way. We just had statements from the prosecutor and then Bill Cosby cooperating, which incidentally, his attorneys at the time should be shamed. You definitely want to get that in writing. FYI, you definitely want to get that one in writing. If you think the prosecutor has indicated to you in public that you can cooperate and it won't be used against you, get that shit in writing, ma'am. So I don't know who his attorneys were at the time and how this fairly obvious step somehow eluded them, but it did, which I guess just shows that even money and fame cannot necessarily buy competence when it comes to lawyers. I'm not sure if that's a good thing or a bad thing, but either way. Anywho, the Pennsylvania Supreme Court in the end decided it didn't matter, that these public statements were enough, and that we're going to throw out the case. And Bill Cosby gets to go home, the case is over, you can't retry, go away. That's what the Pennsylvania Supreme Court said. Okay, now the state of Pennsylvania wants to appeal to the U.S. Supreme Court. And that's kind of weird, because as I've explained on this channel more than a few times, the U.S. Supreme Court only has power to decide federal issues. They're the Supreme Court of the United States, which means they have the power to decide laws of the United States. They have no power to decide the laws of Pennsylvania. If you want to know the laws of Pennsylvania, go ask the Supreme Court of Pennsylvania. That's what they're for. So you can't appeal purely state issues to the U.S. Supreme Court. So you might be wondering, okay, well, what is the federal hook that Pennsylvania is going for? All right, well, I'm just going to read it to you because it's only a page long. All right, so this is from their writ of certiorari, or I guess their petition for writ of certiorari, I should say. So writ of certiorari is what the Supreme Court would grant if they were going to hear the case. So this is a petition for the Supreme Court to grant that writ. All right, now there's obviously some other things. But the main argument that is on here is only one page long. This is not a promising sign, guys. This is not a super encouraging sign. When you're going to the U.S. Supreme Court and your main thrust argument, the one that really is going to matter here, is only 1 page long, it says you don't have a lot to work with. But that's okay. We'll read the 1 page anyway, and then we'll discuss it. So here's what they are saying. The issue that they want to decide: whether a public press release grants a defendant transactional immunity, which is, as it implies, immunity from anything in the criminal transaction. And a criminal transaction is all the things related to a criminal act or acts that are part of a common concert plan, blah, blah, blah. So all the things, immunity, is an important due process issue that, oh wait, actually we needed to go to number 1. I'm sorry. That was number 2. That's an important due process issue, but we don't have to decide number 2. Let's go to issue number 1. The Pennsylvania Supreme Court granted relief under its erroneous construction of the Due Process Clause of the 14th Amendment without an independent and adequate state ground. This error requires correction by this court. All right, so what they're saying here is that the Pennsylvania Supreme Court, when it decided the issue, decided it had to throw out the case because of federal law. Right? Federal law is superior to state law, because of the Supremacy Clause. And so what the state of Pennsylvania is trying to claim is that the Pennsylvania Supreme Court, when they decided the issue and they threw it out, they were basing their decisions on federal law, on federal decisions, and they've misread the federal decisions. And they also say there's no independent and adequate state ground. Because, as I mentioned, Pennsylvania law is an issue solely for Pennsylvania. So if you assume, for the moment, the 14th Amendment does not require this, Pennsylvania, as always, can go further. There's nothing preventing them from going further. They can always do more. So Pennsylvania can always say this is required by our Constitution, at which point that's the end of the discussion. The prosecutor wants to argue that the Pennsylvania Supreme Court, in its analysis, didn't have independent state grounds, that they decide the issue on federal law. Okay, let's read the 1 page. In reversing defendant's conviction and barring further prosecution, the Pennsylvania Supreme Court held that when a prosecutor makes an unconditional promise of non-prosecution, and when the defendant relies upon that guarantee to the detriment of the constitutional right not to testify, which sounds suspiciously like equitable grounds rather than legal grounds, the principles of fundamental fairness that undergirds due process of law in our criminal justice system demands the promise be enforced. All right, in reaching this conclusion, the court relied on Santobella versus New York, various third and other federal circuit opinions, and Pennsylvania case law applying federal due process analysis. Okay, so they want to say that they misread this case, Santabello. They misread Third Circuit precedent, which they're in the Third Circuit. They misread other circuits' opinion, and all the case law they cited applied federal due process analysis. Now, I sped read the decision, my friends. I sped read the decision, the original decision, which I won't, make you go through. But I read the original decision from the Pennsylvania Supreme Court, and I saw quite a lot of citations to Pennsylvania law, it seemed to me. I did see them cite this case, Santabello. I did, but it was for like 1 sentence, right? They have 1 sentence, and they say, see this case, right? So they're kind of throwing it away as an aside or as part of their rationales as they're thinking through the issues. Incidentally, not only did Pennsylvania cite this case from the U.S. Supreme Court and cite the Third Circuit and cite other federal circuits, you know what else they did? They also cited cases from other states. They cited cases from other states. There was a whole footnote where they describe, decisions from other states, like Utah, for example. And Pennsylvania is trying to figure out what its own state law is. And Pennsylvania, in the process of figuring out what its own state law is, can do whatever the hell it wants because it's the state of Pennsylvania, right? So there's nothing requiring them to. On the other hand, there's nothing stopping them from doing it. So they're like, okay, we want to go consult a bunch of states on their law. So here's a citation from this case in Utah. Here's a citation from some other state and another state and another state. Here's something the U.S. Supreme Court said once. Here's something the Third Circuit said once. Here's some other federal cases. Here's a whole bunch of citations to our own case law. it sounds and reads very much to me, my friends, on a speed read, and it is a speed read, I will admit, but it reads to me, my friends, like here's a whole bunch of people who have opined on subjects around this issue. And we, as the Pennsylvania Supreme Court, have decided, because we want to, because we can, we have decided to look at what other states / other places have done in part of determining our law. Now, incidentally, at the end of that process, they can say, you know, because when it comes to Pennsylvania Supreme law, they're master, remember? So they can say, hey, the U.S. Supreme Court said this, and the federal circuit said this, and Utah said this, and Florida said this, and you know South Carolina said this, and so forth and so on. And the next line after all that can be, and also screw all y'all. This is what we're going to do now, because it's Pennsylvania, and they can do whatever the hell they want. They're a sovereign state. So when it comes to their own state law, they can be like, well, this is what every other state has done. This is what other people have done. We're going a different direction because we can, because we're sovereign. Or the exact opposite of those things. We're like, yeah, that's what everyone else thinks. We kind of think the same thing too. Either one of those things would be fine. Okay. So the court specifically noted under Pennsylvania law, federal and state due process principles generally are understood as operating coextensively. This seems to be true, but it didn't appear to me that it was really a due process based issue. Right? The Pennsylvania Supreme Court didn't really seem to think or really say that it was a due process issue. What they said is it's a matter of contract law, which is decidedly a state issue. Full stop. It's decidedly a state issue. So, you know, what makes a contract? Well, what makes a contract is a matter of state law and depending. So let's read again what the Pennsylvania Supreme Court said, right? In the paragraph they said, right? So this is the one paragraph they cited, which is kind of damning to their own case. When a prosecutor makes an unconditional promise of non-prosecution and when the defendant relies upon that guarantee, right? So what they're saying, in other words, is Pennsylvania made what we call in the biz a unilateral contract offer. A unilateral contract offer. Most contracts in your day-to-day life are bilateral. There are two people both exchanging things, right? So every time you go to the store and you buy anything, that's a bilateral contract. Obviously, there's no paper, but you don't need paper for a contract. You have a contract in fact. It happened. I bought an apple. I paid you for the apple. It's apple for money. That's a contract, man. End of contract, right? It's not a complicated contract, but that's your typical contract. Or if you have a yard sale where you're offering a bunch of things at various prices, that's bilateral because there's negotiation, right? And people can like offer other things and stuff. So that's bilateral, right? What makes a unilateral contract, it's a special kind of contract. Or it's a different kind of contract, at least. A unilateral contract sets out all the terms, and a unilateral contract can only be agreed to by doing the thing, right? So when it comes to a bilateral contract, when it comes to a bilateral contract, you can enter into the contract by promising things to occur in the future, right? Which is not infrequent, like I'll pay you tomorrow for the apple today. Or you can agree to contingencies, or you can agree to like all kinds of things that may or may not materialize in the future. So you can have contracts that have contingencies and all this crap. Like, so you don't have to perform on the contract to accept it. You can just sign, you can agree, you can just do that. You just sign, exchange, and promise. But a unilateral contract isn't like that. A unilateral contract is one where you have to perform the contract in order to accept the contract. The only way to accept the contract is by performance. You can't say orally, you can't put it in writing, you can't make a promise. You have to do the thing. What is the thing? Well, it's whatever the unilateral contract specifies. Now, I'll give you a classic example. A classic example of a unilateral contract that maybe you've seen in your life. You're going around and maybe on a telephone pole or maybe on a community bulletin board or maybe posted to a wall, you see a sign and the sign says lost dog, reward $500 for safe return. And it gives you a picture of the dog, right? And maybe some contact information, hopefully, or this is going to be really short. But that's an example of a unilateral contract, right? You can't agree to it orally. You can't agree to it in writing. You can't agree to it by promise. There is only one way to agree to the contract: by performing on the contract, namely showing up with the dog. The piece of paper is a unilateral contract. It sends out all the terms. Dog, $500. That's a unilateral contract. So Pennsylvania said, hey, wait a second. When you guys made this unconditional offer openly in the press, and Cosby relied on that, we think, as a matter of our state law, a unilateral contract was created. Now, Pennsylvania doesn't have to come to that conclusion because, once again, Pennsylvania, incidentally, a good 20 states or more have abolished unilateral contracts. So it's not even a thing in every state. I'm not even sure if it's generally a thing in Pennsylvania or not. It could be just for this thing. I don't know. But either way, they said whether they have them generally or not, this is a unilateral contract. And he accepted. They could have said not that because they're the master of contract law. So it really wasn't a due process argument from Pennsylvania. So, you know, that's a problem. As this court has noted in Michigan v. Long, when, as in this case, a state court decision fairly appears to rest primarily on federal law, it does not. It does not from your own citation, your own quote of the Pennsylvania Supreme Court says it doesn't rely on federal law. It relies on contract law. Or be interwoven with federal law, and when the adequacy and independence of any possible state law ground is not clear from the face, it's kind of clear to my mind, we'll accept as the most reasonable explanation the state court decided the way it did because it believed the federal law required to do so. Yeah, no, I don't think that's a fair read of what Pennsylvania did in its decision on my speed read. Again, they did cite the U.S. Supreme Court in like a sentence. They did cite other courts, but it didn't seem like they were citing them as authority, or let's put it a different way. They weren't citing them as binding authority. In other words, we don't have to follow. They were citing it as what we call persuasive authority, right? This is persuasive authority. Here's a whole bunch of courts that don't bind us, so it's persuasive to us. And we're looking at it as potentially whether or not it will persuade us. And it has persuaded us. That seems to mean what's going on. This court has said jurisdiction in the absence of plain statement below rested on adequate and independent state ground. No such statement exists in the Pennsylvania Supreme Court. Yeah, but no. The court should have granted the writ to address the serious misconstruction of due process, which I don't think that's what happened. I think it's a contract law case. And that's the end of the entire argument. That's all there is. That's all the things. That's all there is. Now, in addition, let's assume that's not all the things. Let's assume that your friend Uncivil law, as I admitted, sped read the agreement, or sped read the Pennsylvania decision, and is not speed reading it correctly. You know, I haven't really done the full dive, so maybe when you really do the full analysis, or you really think about it really hard, maybe Pennsylvania somehow is right. Maybe it really is rooted on federal law, right? It's been rooted on federal law the whole time. Okay, I accept your premise. Does that mean the Supreme Court's likely to grant certiorari? Well, to answer that question, why don't we just go to the rules of the U.S. Supreme Court? Here are the rules of the U.S. Supreme Court. This is rule number 10 of the U.S. Supreme Court. Consideration governing review of a writ of certiorari. When will we agree to hear your case? Review on writ of certiorari is not a matter of right, but of judicial discretion. And then if we scroll all the way to the bottom, it says this: a petition for a writ of certiorari is rarely granted when the assessed error consists of erroneous factual findings or the misapplication of a properly stated rule of law. So if the screw up is they correctly cite the law, but they just merely misapply it, the Supreme Court doesn't do that very often. It's very, very rare. So let's just review our statistics in our head real fast. The grant rate for the U.S. Supreme Court is something like 0.6% or 0.7%. It's somewhere in that neighborhood. It's not great. It's roughly 1 out of every, 170 cases, give or take, something in that neighborhood, right? So it's very, very unlikely in any case. Second of all, this case appears to rely squarely on state law issues, namely contract. And third of all, even if that wasn't true, the Supreme Court just told you in Rule 10, we are not going to grant certiorari merely because a state screwed it up. So I think the odds of the U.S. Supreme Court hearing this Cosby appeal are roughly 0. But, we could get surprised, I guess. But I don't think so. That seems pretty unlikely to my mind. So they can try anything they want. No harm in asking, I guess, but it's a waste of time. It's just a waste of time. Okay. Yeah. So let's discuss some more things. Let's discuss this Rust shooting stuff, which is continuing on. So, of course, behind the scenes, things are continuing to be investigated when it comes to the Rust shooting. Police have done a 4th search warrant in relation to the ongoing investigation, and there are new exciting details about how live ammunition made it onto the set of Rust. Okay, what are these new exciting details on how it might have landed onto the site of Rust? All right, so here's what we have that is additional. The armorer, Hannah Gutierrez Reed, claimed ammunition on the set had been supplied by Seth Kenny. It's Kenny's fault. The ammo had been picked up from PDQ Arm and Prop LLC, either by Reed or by prop master Sarah Zachary, according to the search warrant. But you're the armorer, though. Kenny told the police on October 29th he might know where the live rounds came from. He claimed that a couple years back, he received reloaded ammunition that featured the same logo as dummy rounds he would normally bring onto the set. So according to the search warrant, Seth described how a couple years back he received reloaded ammunition from a friend. Seth described the ammunition struck out to him due to the suspected live round to have a cartridge with a Starline brass logo on it. Seth described the logo to be a star, an arch, and then another star. He described how the company only sells components of ammunition, not live ammunition, therefore it had to be a reloaded round. Well, strictly speaking, maybe not reloaded, loaded for the first time if it's parts, but whatever. So yeah, apparently this company just sells, components. They don't sell bullets. And so it seems like people in the trade might use this company for their prop bullets, which makes, logical sense, because if you want a real bullet, just go off to, your local sporting store and, pick up whatever, it's fine. But, if you want to, and even for that matter, if you want to reload ammo, you can just get the cartridges basically from anywhere. You can buy reloaded casings for that matter if you're into that kind of thing. Or you can save your own brass or whatever. But anyways, it seems like people use this company's brass for the dummy rounds. But apparently once he received it with a live round in it, which sounds really stupid, incidentally, and also like negligence and recklessness on whoever did that. Because again, if the industry norm, if the industry standard is this round is understood to be a dummy round because of these markings, and some idiot reloaded live rounds into that ammo, into that casing, right? Then you're well on your way to some kind of negligence, recklessness claim, depending on what idiot did that, right? If you take a case that is meant specifically for dummy ammo and load a live round in it, you're on your way. But apparently this is the story of how maybe possibly this round got onto the set. Okay. But we have even more. Alec Baldwin has claimed he didn't pull the trigger. He didn't pull the trigger in the fatal Rust shooting. Alec Baldwin claims he did not pull the trigger, my friends. The gun is magic. It's a magic gun. It's a magic gun. Also, I guess he didn't cock the hammer of the gun. It cocked itself. Okay. That's a little weird, but let's go with that idea. Sure. Alex Baldwin has told George Stephanopoulos, and he's done a tell-all or an interview with George Stephanopoulos. So if you're into that kind of thing, I guess watch George Stephanopoulos. That he did not pull the trigger. I would never point a gun at anyone and pull the trigger, never, the actor said. In the clip, Stephanopoulos points out it wasn't in the script for the trigger to be pulled, to which Baldwin responds, the trigger wasn't pulled. He has no idea how the live bullet was there. Someone put a live bullet in a gun, a bullet that wasn't even supposed to be on the property, he added. So, yeah, Alex Baldwin over here is claiming that this gun, which to my understanding is a single action gun, which if it is a single action gun, for those of you not in the gun trade, right, what you have is you have a hammer and the trigger, right? Every gun, I think I can state this universally. Stephanie will correct me if I'm wrong. Every gun has a hammer and a trigger. I mean, kind of has to, right? Anyways, sometimes, of course, that hammer can be internal in the firearm, not external, in which case it would have to necessarily be a double action because you can't prime it, right? But sometimes the hammer is on the outside, and particularly in the case of Old West guns, which this is one of them. It's a replica of one. And so it would function the same way an Old West gun did, which is usually single action. So in order to fire a single action gun, you have to manually pull back the hammer and pull the trigger every time. Now, of course, you can do this very fast. If you've ever watched anyone speed shoot, have you guys ever watched the cowboy action shooter people? Have you guys ever watched the cowboy action shooter people? They're fun, man. So as I'm sure many of you know, there's a lot of different sporting competitions when it comes to handguns and rifles and shotguns, lots of different competitions. My father, for example, is extremely into skeet. He's very good at it. It is his thing he really enjoys. He spends quite a lot of time with the skeet shooting, which is a shotgun sport with the clay birds that come over and whatever. So anyways, just a description for you guys if you don't know that. All right, so there's different kinds of shooting. Now, personally, I've done pistol shooting, USPSA or IPSC occasionally with pistol shooting. There's also 3-gun shooting, which I've never done, which I'd like to at some point. But then there's the cowboy action shooting. These people are fun. Cowboy action shooting requires you to get into period dress, and you use a period gun with period ammo, and you fire a target. So if you ever go watch these things, just type it into YouTube. Just type cowboy action shooting, and you'll see they're wearing the chaps, and they're wearing the hat, and they're wearing the vest, and they have the guns and the old school holsters, the whole shit, man. And you can see these people, and some of those guys are really good at what's called fanning the trigger, which is basically where you kind of do this motion, and so you can reactivate it really, really fast. It's called fanning the trigger usually. But there's the cowboy action shooter people, man. They're really, really good. So you can do it really, really fast, but still you have to pull back the hammer. So assuming this is a single action gun, which seems likely, not only did the trigger pull itself, the hammer manually cocked itself back. So, you know, there's that. There's that. All right, let's discuss another one before we go to the heavy one of the evening. Kim Potter. Kim Potter's on trial. We are on day 2 of jury selection. We have 9 jurors selected. This is the longest jury selection of anyone's life, not only in the sense of time, not only in the sense of the literal time, but in the more appropriately in the sense of the judge, who has a very, very ASMR voice. It's very, very ASMR. So if you guys like ASMR, man, you cannot do much better than the judge in this trial, man. Every time I listen to her, I'm falling asleep. It's brutal. It's brutal. But in any case, we got 9 of these guys sitting. So this is the police officer who shot at someone, killed them with a Glock when they were attempting to use their taser. It wasn't a taser. It was a Glock, as it turned out. So they want to get 12 jurors and 2 alternates. and they're being charged with first and second degree manslaughter of this shooting. Defense claims it's an accident. Prosecutors say reckless and negligence. And they have also revealed that former officer will take their stand, which is probably not a stupid idea, or not a stupid idea in this because, you know, first of all, there's not enough external evidence like there was in the Rittenhouse case. And second of all, it's a former police officer. So they are, you know, going to probably be a little better than your average client. So it makes a lot more sense here. So, and then the judge, of course, reminds everyone that she doesn't have to testify. Now, what was really, really interesting today, Let's see if the thing discusses it. They don't really discuss it in depth. They just, 32. They're 32. This juror 32. So they don't really discuss it in any depth. But juror 32 in this case was based. Yeah, they don't discuss it in this at all. I watched the voir dire process of juror 32, and juror 32 is based. Juror 32, if you're out there somewhere, I want to let you know you have an open invitation to appear on Uncivil Law. You've not been allowed on the case, so you know, no prejudice. But we'd love to talk to you. Let me describe you a little bit about this woman. All right, first of all, this woman is a big fan of Blue Lives Matter, and she's a big supporter of the police. She served in the Army for 2 years. She didn't like it though, so that's why she left. But yeah, Jerry McCulloch is the shooter. I agree with you, Stephanie. But so she left. But since then, she's worked as security at her church. She was on the church security team. And although the church security team at her church doesn't require you to be armed, based juror number 32 over here decided to get a concealed carry permit and was carrying a gun at the church for the purposes of offering security at the church. Base juror number 32 over here. Base juror number 32. It's like, yeah, I use guns. I'm a big supporter of Blue Lives Matter. And the prosecution in the voir dire of this witness was pretty hilarious because they really wanted her to disqualify herself, right? Because as the article noted, the state had to burn its last preemptory challenge. A preemptory challenge is where you get to kick someone off the jury just because you want to, but you only get so many of those. And they had to burn the last of them. So the prosecutor was up there just trying to ask every possible way and asked the same question so many times to the point the defense actually objected, and they sustained an objection during voir dire for asked and answered, which is pretty hilarious. But basically asking every possible way. So they said to him, do you think you'd be biased in favor of the police? She said no. He said, you think you could put away your biases? She said, yep. He said, you took a gun safety course when you got a concealed carry permit, right? Right, I took a gun safety course. Would you be able to judge this case based only on the information that's offered in this trial as to gun safety courses and not what you learned? Yep, no problem. No problem. I can do that. I can do all those things. So that was pretty hilarious. With base juror number 32 here. So I don't know if she's out there somewhere, but she has a fan in me. All right. So now I'm going to give a content warning. I guess I'll even put it in chat. We'll just put that right up there so we can do this. All right. So we're going to read a little bit we're going to read quite a bit actually from this Josh Duggar case on these motions, because there's some good areas of law we can learn about particular information coming in and when they're not. So this case deals with photos of underage people who are being exploited in a prurient fashion against their will So, it's an uncomfortable subject matter. So I just want to give everyone a heads up on that so that, you can bail out if you want. But we're going to go over this because there's some good law in all this, okay? So anyways, Josh Duggar has been charged with 1 count of receipt of this stuff, 1 count of possession of this stuff, and forfeiture. The government has filed notice pursuant to Federal Rule 414 and a motion in limine to admit evidence in relation to prior conduct. So, what is rule number 414 of the Federal Rules of Criminal Procedure? Well, as I'm sure many of you know from our discussion, for example, of Kyle Rittenhouse, typically speaking, you can't bring in someone's past acts as a matter of trying to prove that what they did now they did, right? You can't bring in someone past acts. So one of the reasons that we didn't bring in the history of, for example, Rosenbaum in the Rittenhouse trial was because of rules that make it non-admittable. We don't bring in people's prior bad acts because what we care about is what you did now. But when it comes to prior physical touching of children, there's a special rule for it in the federal government. It's called rule number 414, which allows prior acts to be brought in. So there's a special rule about it. Okay. So the defendant has filed an opposition to this, arguing the government did not comply with the requirements because they didn't send notice in sufficient time. So the rule requires the prosecution to give defense notice 15 days before trial. And they say, well, they didn't do that. So the court has heard this motion. When the court pressed government to describe the witness testimony intended to present, basically, what is your proffer? What are you going to be saying? The government explained it planned to call 2 witnesses, but only one of them was under subpoena. The other witness had not yet been located and served. Because it was not entirely clear what the 2 witnesses would say, the court set a follow-up hearing to preview the evidence and make findings. So yeah, the court needs to ask a little bit more, right? Because you're asking to admit stuff that's not normally admissible. You're asking to admit stuff that's normally not admissible. There's a special rule for it, but the court still wants to know, like, what are you going to be arguing? So we can determine that you're offering stuff that's within this box, right? And not stuff that's outside the box. We don't want you to offer stuff that is not within the confines of this rule. Like, as long as I'm discussing the stuff that's within this rule, let me sneak in some other stuff that isn't related to the rule, but I'll sneak it in. So one of the reasons they want to do this is to make sure that doesn't happen and make sure that you're only offering testimony within the box. So basically, they're going to hear from the witnesses, or at least hear a proffer about what they're going to say before they're ever allowed to take the stand, to make sure that the testimony will be sufficiently confined to the rules. So they grant the government's motion and the defendant's motion is denied. So the defendant lost this. So let's discuss why. So the actual rule 414B states, if the prosecutor intends to offer evidence of prior touching related to children, the prosecutor must disclose it to the defendant, including witnesses' statements or a summary of the testimony. The prosecutor must do so at least 15 days before trial, or if at a later time, if the court allows it for good cause. Defendant maintains the notice is not sufficient because it does not provide witnesses' statements, because apparently they didn't know who this witness was. On November the 15th, 15 days before the trial, the government sent a defense team an email identifying the witnesses who were expected to testify in a summary. The court later received a copy of this email. The court finds the government's notice was sufficient and timely. To the extent the original notice did not provide enough detail, the follow-up email of November the 15th, which is the same day, so still within the time frame, advised the defendant of evidence the government intended to present. So all the information was given to you exactly 15 days before the trial. So Federal Rule of Evidence 414 is an exception to the general rule of evidence that past crimes may not be used to prove the character of a person or to show action in conformity. So you're bringing it in as character evidence, which normally you can't do. The rule will normally supersede in these kinds of cases the restrictive aspects of the rules of evidence on 404, which deals with when you can bring in prior bad acts, right? So it brings in those restrictive aspects as well. Ninth Circuit has described Rule 414 as a presumption, but not a blank check, which favors admissibility but doesn't necessarily require it, because 404 itself deals with admissibility of prior bad acts, and so 404 is still in play, but 414 supersedes. So if 414 doesn't cover it, 404 still applies. So that's one of the reasons they want to know what's 414, so we can understand what's being superseded and what's not. Rule 414 provides in a criminal case in which the defendant is accused of, the touching of kids, the court may admit evidence the defendant committed any other touching of kids. And then it goes on to define that. It's any crime under federal or state law, any conduct prohibited by Chapter 110, or conduct between any part of the defendant or an object. And apparently, yeah. So the defendant is charged with 2 counts of possession of photography of this stuff. Defendant is therefore accused of the touching of children as defined by the law. The government asserts it can prove this by preponderance of the evidence. So this is another thing too, right? When it comes to Rule 414, it doesn't have to be crimes you've been convicted of either. It doesn't have to be crimes you're convicted of. It doesn't have to be in crimes you were charged with in the past. In order to bring it in, they just have to show preponderance of the evidence for it to bring it in. More likely than not, you brought it in. More likely than not, that's part of your character. So, it's a government, whether or not you think any of this is good, by the way, I'm not going to speak to that issue. I mean, it comes with trade-offs, right? So maybe there's a person who really didn't do it and really didn't do things in the past, but those things are being brought against them now, and it'll make them look guilty even though they're not. So, I mean, there are countervailing considerations here. But, how you weigh those countervailing considerations is kind of a matter of policy, not a matter of law. So then they go on to note here that all of his victims, they go on to note here that all of his victims were under the age of 12, and he was 14 or 15 years old at the time. So, great. Just fantastic. So they note even uncharged conduct is admissible. Whenever a criminal defendant is accused of these crimes, including CP crimes, the court may admit evidence that they committed any other violation. They don't have to be identical to the current charge. They've held that hands-on charges are relevant to show propensity to CP charges. So you can bring all that in. So what are some prior evidence we have? Okay, so we want to bring in this evidence from this guy, Bobby Holt. Or I think I'm going with Bobby. I'm going with Bobby. We want to bring in evidence from this person, Bobby Holt. Now, Josh Duggar is not having a great day of it so far. So he wants to try to offer, okay, Bobby Holt is actually my priest. Bobby Holt's actually my priest. And so he can't testify because all this is covered by priest penitent privilege. So he's my priest, and therefore he can't bring that in because it's privileged. Okay, let's find out if this guy's a priest or a girl or whatever. Apparently it's Miss. So they apparently were longtime friends of the Duggars. Mr. Holt was Duggar's closest friend, and the family anticipated the defendant would marry Holt's eldest child. So they were thinking that they would that their children would get married someday. They both attended the same non-denominational Christian church, and they socialized. So they objected on the basis of common law clergy privilege. After some count discussion, the court permitted Ms. Holt to testify, subject to objection to the court's ultimate ruling. So all evidentiary privileges are assessed in federal court are governed by the first instance of Rule 501. The rule states the common law is interpreted by the United States court in light of recent experience governs claims of privilege. The existence of priest penitent privilege, which recognizes the human need to disclose to a spiritual counselor in total and absolute confidence what are believed to be flawed acts or thoughts, and to receive consolation and guidance. So the court believes it's within its discretion to consider the applicability of this privilege on case by case, bearing in mind these privileges are not created likely, for they're in derogation of the search of truth. They prevent the search of truth because they prevent someone from testifying. So the Third Circuit has held clergy privilege under federal common law protects communications to a clergy person in their capacity with a regional expectation of confidence, which is pretty typical, by the way, for most of these states, right? You have to be talking to a person of the clergy. They have to be actual clergy. It has to be in their spiritual capacity, which is a big deal, right? So if they're just your friend and you're just talking to them as a friend, it doesn't count. It doesn't count. It only counts if you're talking to them in their spiritual capacity. So, you have to like distinguish out. Was it just a friend, or was this, did you go into the confession booth or the equivalent, or is this just more friendly? And also, more importantly, or perhaps you have to have a reasonable expectation of confidentiality, so someone can't overhear you. So the Third Circuit defines clergy person as minister, priest, rabbi, or some other functionary of a religious organization or individual reasonably believed to be so by the person consulting him. So, you basically have to be, an actual priest. The threshold issue in this case is whether Holt qualifies as a clergy person. Here's the following testimony. Question, this is questions of them, not at trial. This is questions of them to determine if this witness can testify, right? So this is a pre-trial hearing in which this person is being called as a witness for the purpose of deciding whether or not they can be called as a witness, right? So here's what we have. Question, whenever you attended church with the Duggars, did you ever hold yourself out as a position of authority within the church? No, ma'am. Were you ever a pastor of the church? No, ma'am. Were you ever an elder of the church? No, ma'am. Were you ever on any sort of church council? No. Did you hold any sort of role besides parishioner with the church? No. The government counsel then asked Miss Holt why she never held a position, giving her longstanding membership, and she explained women weren't asked to be elders or pastors in our church. So that makes it a bit of a problem, right? It makes it a bit of a problem. In this particular church, they don't let women be pastors or elders. So it's a little bit more conservative of a Christian church. So kind of hard for you to be a priest or penitent of this church, which you guys go to on the regular, when the church, as a matter of its faith, says that women can't be in leadership positions. So how can you be in a leadership position? Kind of hard. Kind of hard on that one. Don't really think you're a priest there. Not buying that one. In response, defendant suggests Holt should be considered a clergy person because her husband was an elder. Oh, okay. Because your husband is an elder, that makes you an elder. That's definitely how it works. If I get married because I'm an attorney, my wife is an attorney too. Ugh. Yeah. The court rejects this contention, finding no credible evidence Holt held a position in the church, analogous to that of minister. Defendant argues Holt's conversation with defendant should be deemed privileged because one or both of them prayed or opened the Bible as they conversed. And then state the obvious, conversations between true church members are not shielded from discovery, even if those conversations involve serious subjects and are punctuated by prayer. No, all the no, just all the no. You can't do that one. You can't just because you opened the Bible and maybe prayed and maybe talked in spiritual terms does not priest penitent privilege make. We're all thrilled with your advocacy over here, but no. And then, okay, so Miss Holt in this preliminary testimony, because now that we've determined that she's allowed to testify, because she's not a priest, we still have to go to the next step of the analysis, right? Because again, as I mentioned before, we're only within the 414 box, right? The 414 box controls the 414 box. We don't want you to squeeze things into the 414 box. If it's not inside the 414 box, then go consult Rule 404. That's the normal rule dealing with admissions of character, which basically says, no, you can't do it. All right. So we still want you to testify to, says, can your future possible spouse object to being a lawyer by marriage? Yeah, you're a lawyer. You're a lawyer in law or something like that. That's funny. Anyways, so here's some conversations that we had. So we make sure that we're in the box. So so in March of 2003, they went to the Duggar residence. When they went there, they testified that she and her husband were called that day to discuss something related to courtship between the defendant and Holt's eldest daughter, because they thought maybe they would get married. I think the marriage plans may be off now. When they arrived at the home, they were escorted by them to the Duggar's bedroom, and there the defendant revealed to the Holts that revealed to them that he had inappropriately touched a minor earlier that day, which has been identified as Jane Doe number 4. So that's an interesting 0 to 100 real quick, isn't it? Right? So you're the Holts. You're invited over to the Duggars. You're invited over the purpose of talking about courtship between the defendant and your oldest daughter, for the idea of potential marriage between the two. And then they bring you into your bedroom, and Mr. Duggar over here confesses that earlier that day, I had a little inappropriate touching. 0 to 100 real quick over on that one, man. Woof. Defendant acknowledged that he touched this child while he was sitting on his lap during Bible time and used his fingers to contact her, lower areas. He confessed that he had touched her upper areas and lower areas of 3 other children victims on multiple occasions, sometimes while they're asleep. And the Duggars indicated the defendant's revelations, according to the Holts, that indicated to them that would likely mean the end of the courtship, and that the relationship ended that day. So, yeah, I got some things to tell you. I touched someone earlier today, and in the past, I've touched 3 other children, girls, in their, lower parts and upper parts, sometimes while they're asleep. So, this would be the kind of evidence that you probably don't want being brought against you when the jury is considering whether or not you were in possession of those CP documents. But this seems to be within the bounds of 414, because as I mentioned, 414 deals with exactly this. And this is squarely within the rule of 414. So, Miss Holt can testify to this at this trial. Hope that works out real well for you, Mr. Duggar. Miss Holt also testified to a second conversation, which took place at the Holt's home in 2015. Even though they had formally terminated the relationship, the Holts testified the two families still loved one each other, and they held out hope the relationship between the teenagers might yet be salvaged. Wow, Christianity does preach forgiveness, so I suppose that's that. There's that, but man, that's a lot of forgiveness, man. Although strictly speaking, that's a problem. It's a problem. To that end, the Holts invited the defendant to live with them for a brief time, so they have the time to talk with him, get to know him better. Miss Holt testified that one evening, the defendant entered her bedroom to talk with her and Holt. He confessed to Holt that he had not told her the complete truth about the past incidents of the touching. Specifically, he told the Holts in 2003 they touched Jane Doe 4 over her clothes and under her clothes, and he admitted to using his fingers to insert them inside the child, which incidentally does technically qualify as rape on top of everything else. So I don't know if we're ever going to charge him with that, but could be. Okay. Again, these girls were like 12 at the time. So there's that. Yeah. So based on this testimony, the court finds by a preponderance of the evidence that, yeah, you've done the prior bad stuff. Defendant's father, Jim Bob, his name is literally Jim Bob, it's kind of hilarious, testified at the hearing and largely corroborated the testimony. For example, he agreed defendant had inappropriately touched the 4 children, but he was a little bit more hazy on the details. He recalled defendant inappropriately touched the children on their tops while they were sleeping on more than one occasion, but beyond that, memory failed him. Well, your memory might fail you, but the memory you do have, I'm sure, will be very interesting to the jury as the father of this person. It's like, I may not remember much, but I do remember this one time, this one thing happened. Would the jury like to hear about it? I think so. Okay, then we have Rule 403. So we have Rule 403, which is our last saving grace over here. All right, so Rule 404 deals with the prior admission of bad acts, but Rule 414 supersedes it when it comes to the touching of the children thing. But Rule 403 is our last sanction, our last refuge in our course of conduct, because Rule 403 says evidence can still be excluded if it's substantially more prejudicial than probative, right? So even if evidence is relevant, even if it's true, even if it's, even if it checks all the other boxes, Rule 403 allows you to still exclude it anyway if it's substantially more prejudicial than probative, right? If it's probative, it goes to whether the defendant did or not. So all evidence is a little bit prejudicial, because all evidence necessarily is going to make it a little bit more or a little less likely he did it, or otherwise it's not evidence. For it to be evidence, for it to be evidence by the letter of the rules, it has to necessarily make it at least somewhat more likely or somewhat less likely. It has to move the needle in one direction to some degree that the defendant is more or less guilty. That's the nature of what evidence is. If it doesn't move the needle, it's not evidence. So necessarily by moving the needle, especially if it moves it into the guilty direction, that's necessarily prejudice to the defendant, because, hey, we're making them look more guilty, aren't we? So the rule says, okay, substantially more prejudicial. Like, if they heard this fact, it would just go off the charts, and they would do it because of completely invalid reasons, right? So we do have the saving grace Rule 403. How do you expect that's going to work, by the way? How do you think that's going to work? I can tell you how I think it's going to work. So relevant evidence of the prior conduct should not be admitted if its probative value is substantially outweighed by danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. So, as the first factor, the court finds, based on the government's proffer, which is what people will testify to, which in this case was augmented by the person saying that what they'll testify to, that the prior acts are clear and compelling. The government makes a preliminary finding a fact finder could reasonably determine the defendant committed this, as defined by the rule. As the second factor, the court finds the government's evidence is probative of propensity to commit these CP violations to which he's charged. The CP victims in this case are approximately the same ages as the victims of the hand-on molestation. Gross. The prior act is probative of sexual interest in, 12-year-olds and his propensity for exploiting them. Defendant contends that the hands-on offenses took place approximately 18 years ago, and the fact diminishes the probative value of the evidence. Given controlling precedent, the court disagrees. The Eighth Circuit has opined that 20-year-old acts of the touching were admissible in the defense CP trial, and the age of the prior offenses did not establish unfair prejudice. The court also observed that Congress placed no time limit on admissibility of the evidence. Defendant also argues, without any citation to any law, that allegation concerning alleged conduct by Duggar as a juvenile sheds no light on whether Duggar knowingly received the CP on 3 days in 2019. He claims the probative value of the acts alleged by a child is at minimal, best with respect to crimes committed more than 18 years later. So he's trying to say because it was a juvenile, then that's different. The Eighth Circuit has affirmed a trial court's admission of hands-on evidence that defendant allegedly committed 20 years later when he was 17 years old. So in almost the exact same factual posture. So as the relevant age case, the age of the person doing it was not the factor. So there's no serious dispute about the facts surrounding this. The defendant father and Ms. Holt testified to the same facts. And they apparently defendant's father testified that he and his wife appeared on a nationally televised talk show in 2015 and openly discussed these acts against the 4 children. That should be interesting testimony. And it doesn't appear that less prejudicial evidence can show this propensity. There's little doubt that the rule, if introduced, will be prejudicial. But Rule 403 only counsels against unfairly prejudicial. So, yeah, no, all that evidence is coming in against you. So if you want to know how it's going against Josh Duggar, the answer is not well. It's not going well against Josh Duggar. We've discussed quite a lot of law today, haven't we, though? We discussed Rule 414, and Rule 404 and Rule 403 and priest penitent privilege and substantially more prejudicial than not. We got one hell of a legal education out of this nightmare. But, you know, the government has the photos. They have the photos. And now they have the testimony of Miss Holt and the defendant's father who say, yep, he did those things. I remember when he did those things, told me about those things. I remember those things when he told me about that. So how do you imagine that's going for the defendant in this trial? Not well. Not well. It's not going well. So, you know, I think, you know, basically guilty is basically the conclusion at the end of that. So, no. Yeah, and he's facing, what, 20 years? Which he may or may not get all that, but it will probably be aggravated by these prior crimes in some degree. I believe he's facing, I think he's facing 20 years, if memory serves correctly. So he might get, he'll probably get a fair amount of that based on some of this prior shit. So this is going to be really, really fun. Yeah. So how is that? Did you guys learn anything? I tried to cover it as sensitively as possible, right? I didn't want to glorify the details too much, but I kind of felt like I had to like say what they're talking about, like what is the evidence, right? And so I was like, I don't know how to describe this, but I tried to do it in as sensitive a manner as possible. So hopefully that worked out for everybody. So, you know, good times. So that's the end of that. Now let me talk about another thing. The Ghislaine Maxwell trial. I have concluded, at least for the moment, that the Ghislaine Maxwell trial is not a good fit for my channel. I have some concerns about the case that are not the major narrative. They kind of go against the major narrative, and I don't know a way to describe them in a way that would be suitable for the channel, because I've had this problem before, as I'm sure some of you know, where I describe things like this, and sometimes it can be a real problem where people are trying to determine what my views are, or what, like when I'm trying to play devil's advocate, sometimes it can be a real problem. And so it can be a particular problem in cases like this where I have to do devil's advocate in cases where some people are testifying about things that happen to them while they're minors, and, you know, having to deal with that. So that's all I'm really going to say about the Ghislaine Maxwell trial. I'm not going to be covering it because I just don't think it's an appropriate fit for my channel. So sorry about that, but no, I don't think we can do it. I might change my mind if I can really figure out a better way to do it, but yeah, I don't, you know, I don't think there's a good way for me to do it. So I'm going to skip it for now. So anyone else? Let's read a few super chats from you guys. Herod says, wow, I'm unsubscribing. You can't please everybody, man. Why stop? Why try? Oh, you're kidding? I'm glad. Let's see if the bot has captured anything for super chats. $5 from Fiery Red Podcast. Told you I owed you a super chat. My ignorance of the lie is no excuse was wordplay. Please keep joining Nick for the Potter trial and invest in it. Well, when we get to the actual trial, maybe. $2 from Clumsy Clairvoyance. Sounds like Baldwin was wreaking havoc. That's very cute. Let's read some of your questions for the bot. I thought it was promissory estoppel, which is different from contract law. Either way, if it's promissory estoppel, either way, it's state law. So if you view that as a promissory estoppel thing, the language is a little bit muddy. The language is a little bit muddied from the court. So take your pick between contract law and promissory estoppel. Maybe it's one, maybe it's the other. The language was mixed, but either way, it's an issue of state law, so it doesn't change on that. Because if it were an unconditional promise, there would be no consideration. No, there still has to be consideration. Unconditional promises do have to give consideration for there to be a valid contract. Guns that are slam fire by design don't have a trigger. Okay. Erica said, Uncivil Law and Stephanie, thank you for the respectful handling of the topic and discussions. I tried. And I'm glad you appreciate the coverage of the Daybell and... Okay, so one more super chat. Mithrin Emrys. Kurt, if you don't feel like a case is right for your channel, don't cover it. I, for one, come here because you will play devil advocate. Understandably, some cases are hard to do than others. Yeah, you know, it's just not going really, really well on that one. So, yeah, but that's all there is for tonight. That's all there is for tonight. So I'm going to sign off for now. Thank you for everyone who's here. Thanks for everyone who's a subscriber. Thanks for everyone who's checking out my content. If you haven't seen the 1.5-minute video I put out earlier today, where I and Nick and Legal Bite lose our shit over Havoc, then you might want to check that out because that was pretty funny. And also we had a regular video release earlier today as well. So this is our 3rd video for the day. So, you know, we're trying to give you lots of good content. I have also uploaded 7 more videos on the YouTube server that are ready to go. So we have all that ready to go. So lots and lots of good content ready to come up. We'll do it. Please remember to subscribe. Please remember to like. Please remember to do all the join, hit the YouTube bell and all the YouTubey things. I am going to sign off for now. Until later, my friends, I hope all is well. Cheers and good night.